Hello, and welcome to Let's Talk Immigration, whether you're viewing live or you're viewing later. Um, First thing I want to talk about today is something we talked about in our live Tuesday with Farshad yesterday in Farsi, and that is we get a lot of questions about what a motion to dismiss is. And I think the most important thing to ask an immigration attorney that you are hiring for a mandamus or an unreasonable delay lawsuit against USCIS or the State Department um, is this question: what happens when the government or if the government files a motion to dismiss? The reason is some of my colleagues and competitors uh, deal with this very differently than we do. And it varies, okay? Some immigration attorneys are not prepared to fight a motion to dismiss. Some are prepared to fight, but they charge an additional fee. That's what we used to do. Some charge an a great big additional fee, okay? At Ready Go Law, if we stand for anything, it's that we want to advocate for you um, as strongly as we can. Okay. We want to be a fierce advocate for you. And so when the government files a motion to dismiss at Ready Go Law, we fight back. We prepare and file a response in opposition. We file it with the court. We use our page limits. Usually we have exhibits. If there's a hearing, I show up or one of our attorneys show up and we make arguments on why we're right and the government's wrong. And we let the judge decide whether or not to grant or deny the motion to dismiss. We don't just give up. Okay. So, actually, my team has put together a little slideshow to convey what I just tried to say. Understanding a motion to dismiss. Sometimes they call it an MTD. A motion to dismiss requests the court to reject the case, to just stop the case. When does a motion to dismiss happen? Under the federal rules, after we file a mandamus lawsuit, the government, we serve it. And then after it's served on the U.S. Attorney's Office, the State Department has 60 days to file a response of pleading. That response of pleading can either be an answer to the complaint where they answer each allegation, or it can be a motion to dismiss under Rule 12B. Very often, especially with Iranian visa applicants, what we see is a motion to dismiss. But that's not the end, okay? That's when it's time to show our stuff. It's time for us to file our response in opposition. So many visa applicants think the lawsuit process is over when that ideal scenario does not happen, which is more often the case since May 2023. We did not see as many motions to dismiss a year ago and before, okay? And the State Department files a motion to dismiss. Often we read in Telegram groups where uninformed plaintiffs will panic and exclaim, "My lawsuit was dismissed." Okay. However, when the State Department files a motion to dismiss, that does not mean the judge will agree and grant the motion. Given the benefits of a thorough opposition to the motion to dismiss, judges can and will deny that motion. I have a blog entry on our website where we've itemized 20 times that's happened in the last year. Many of those orders were ours. Okay. What's the next thing here? At Ready Go Law, we oppose motions to dismiss and we fight for you. That's the takeaway. That's what we want everybody to remember. So we are prepared to fight defendants' motions to dismiss. It's part of our agreement and we'll support you to the end. Okay. When you hire us, it's not just get your money and then we forget about you. We will fight for you to the end. Okay. Thank you for viewing. Great. What a great way to start the day. So if anybody has any questions that they would like to pose, especially if you post them on Facebook or Twitter, or YouTube, they'll show up here and I'll see them. If you post them on Instagram or Telegram, I think my team will see them and they'll copy them, I hope. What else do I want to talk about this week? Iranian family-based group lawsuit. Okay, I had said that we would start onboarding that case middle of September or middle of October. Actually, I said both. And now we're past the middle of October, and some of you are wondering, when are you going to start onboarding it? I get lots of emails. We've got over 100 people on the interest list ready for that lawsuit. I have hesitated to onboard it yet because I really wanted feedback from one of the 3 lawsuits that we filed before like this, from developments that are ensuing, that are about to happen. Okay, those 3 cases are Taharian, Pars Equality Center, and Badfapo. Taharian and Badfapo are in the Central District of California in LA, and Pars Equality Center is in the Northern District of California in San Francisco. I have reason to believe that there's going to be a development in all 3 of those lawsuits in the near future. Okay. Actually, in Taharian, we got a clearance this morning. So even we keep those lawsuits alive until everyone's visa is issued. In PARS, I think we have 2 or 3 families. Taharian, it's like 4 or 5 families. And Badfapo has a lot more families, like 33 of 37, because it's the most recent lawsuit. Badfapo is interesting because Judge Carter, who heard us in oral arguments recently, seemed like he was entertaining our policy challenges in a great way. He understood what we were saying. However, he was asking some questions about joinder. The government made some arguments that maybe the plaintiff shouldn't be joined together. And so he may divide that case up or something. So we kind of want to wait and see what happens with that. So I do think that we will be offering this next group lawsuit in the next couple of weeks. We'll be announcing it. But I'm hoping that we can get some information, some being informed from the prior judge's orders in at least one, but hopefully all 3 of those lawsuits, right? Taharian, we would not get an order because we have a hearing in November. So but we would learn something from the hearing. Okay, so that's family-based Iranians and AP. If you wanted to sign up on the interest list, this is the link. Okay. Other things I was going to talk about, students. If you're a student, Iranian student or a Russian student hoping to attend school in the US in the spring semester and you're in AP, now, today, yesterday is the time to file a lawsuit, not wait till November or December. Lawsuits are not like Coke machines. You don't go in, put your coins in and expect to just get the Coke out. Lawsuits take time, okay? So if you are concerned about what's happening with Israel or Ukraine or Trump, and you want to ensure against bad things happening in the future and get your butt in the United States before bad things happen, now is the time to hire us for a lawsuit. I'm going to be telling people, a lot of people know in November and December, primarily November, that are going to come to me, students that are going to come to me, oh, can you help me get into school in the spring? No, that time to do that would have been September, October. Okay, that's it. So I'm surprised that I'm not hearing from more students. I'm hearing from more students that act like they'll make the decision next month after it's too late. I don't get that. Okay, stop that. If you're a student and you want to enter school in the US in the spring semester, you need your clearance as soon as possible. You can't be waiting till the last minute to file a lawsuit. Okay, I think I have explained that thoroughly now. So I have a question here. Let's go ahead and jump in. Asan says, "Dear sir, I'm stuck in administrative processing for 19 months with DS 5535. I filed a mandamus lawsuit, but unfortunately I lost the lawsuit. I want to know, should I file another lawsuit and what will be the success chances?" Okay, Hassan, when you say you lost the lawsuit, that could mean a couple different things. It could mean the government filed a motion to dismiss, you opposed it, and the judge granted the motion. It could mean you voluntarily dismissed because your attorney didn't want to fight back. It could mean you survived the motion to dismiss and then you went to summary judgment and you lost summary judgment. I don't think that's happened, or I would have known about it. Um, so I'd want to know more details about the procedure, the court district. I'd want to see the order to answer with precision, but I'm going to answer generally. Okay. Generally, I don't think it's I would not give up, right? So you can always file another lawsuit challenging the length of delay when the length of delay changes. If the legal issue is a 12-month delay is unreasonable and the judge says, um, motion to dismiss granted because that is reasonable. Well, guess what? 19 months is longer than a year. So you have a new claim. Okay. It is a distinct and different claim. So if you bring it in the same district, it will likely get assigned to the same judge, but that doesn't mean it would get the same outcome. But you could also possibly bring it in a different district depending on your situation. I don't see your visa category. If you're a student and you're not located in the US, you're kind of stuck on the venue situation on which course you can use. You can use DC, or our firm is now doing a novel approach and using the Eastern District of Virginia, because that's where, after you completed the DS 5535, the consular officer was supposed to send a request for a security advisory opinion to the SAC office, but as a non-immigrant visa, it would go to Sterling, Virginia, at the National Vetting Center. Oh, it says you're okay. The government came with a motion to dismiss, and judge granted the motion. Okay, I see what you're saying. So the lawsuit was dismissed. Visa category is K1. Okay, so K1 is an interesting category because it is a non-immigrant visa category, but it's treated like an immigrant visa category in many contexts. I am not sure 100% certainty whether or not SAO requests for K1s are being resolved in Sterling, Virginia at the National Vetting Center, or in Washington, D.C. at the Office of Screening, Analysis, and Coordination. I have several members of Congress that I have been trying to get to answer that question. Let me rephrase that. I've been trying to get them to ask the question of the State Department to get the answer. I've been trying to get our clients to ask their members of Congress to ask that question of their, because the State Department will answer a member of Congress. They will not always answer my questions, right? I want you to reach out to me, Asan. I don't Telegram, WhatsApp, or email, because I am putting a list together of K1's in AP right now. K1's fiance, if you all don't know it. I'm talking to an institutional, a nonprofit plaintiff about putting together a group lawsuit just for K1s, called the Star-Crossed Lovers lawsuit. Basically, we're seeing more and more fiancés stuck in AP for a long period of time. And I've already got a few people on that list. And I'd like to put you on that list because group lawsuits, they accomplish two goals. They're more affordable, but then also they give us an opportunity by pooling everybody's resources to challenge the cause of the delays. Okay. Instead of just going into the court and saying these delays are unreasonable, we go into the court and say these delays are unreasonable because the 221G scheme is unlawful. The DS 5535 scheme is unlawful. And I like to be able to challenge the cause of the delays, because if we can get them to stop doing what's wrong, then we won't have as many problems. Okay. So you'll email with complete details. Great. Let me put my email up here. Maybe somebody else might want my email too. Create a banner. Put my email here. It's curtis@readygolaw.com. That's That's my email. Okay, great. Um, okay. So I don't see any other comments. Is there anything else I wanted to talk about today? Um, Talked about family based, talked about students. Employment based, we have some pending cases for employment based in AP, and we're going to continue to file those lawsuits. We're not currently onboarding a group, but if you want to form a group yourself, um, on our Telegram channel, I've actually set up mini groups where people can form their own group. Like I think I type H1Bs, O's, O1s. Like if you go in that group and then you get a group of people that have the same length of delay relatively, like 10 months to a year, or a year to 2 years or something like that. Just what you don't want to do is have somebody that just had their interview 2 weeks ago with someone that's 2 years after the interview, because then the length of delay, it's a different legal issue, right? Okay. So it looks like that's all the questions we have today, and that's all I really wanted to get across today. So I'm going to cut this week's show short, and I will see you next Wednesday for Let's Talk Immigration. If you do have any questions, there's my email. Hit me up, okay? Have a good week.